Hello, my name is Andrew Nyamayaro. I'm a solicitor at Law Solicitors, and today, the 13th of May 2025, I am going to make comments on the document that was produced by the UK British government. It is a white paper entitled Restoring Control Over the Immigration System. A white paper is a document which is a proposal by the parliament of topics or issues that they would want to be discussed pertaining to a particular legislation that they want to be done. And for those who would be knowledgeable to this, there's so many ways in which legislation or laws are made by the parliament or government. And a white paper is one of the ways in which um, debate is tabled before parliament for topics to be discussed. So this white paper is mainly aimed for immigration. And as we know, immigration in the United Kingdom is also under the Home Office. And Home Office, being a department of the government, also has a delegated legislative powers. And under those delegated legislative powers, they can be able also to make certain laws, um, which do not necessarily have to go through Parliament, but are made through the delegated authority from the Parliament. So today I am commenting about the white paper that was announced by the Prime Minister Keir Starmer yesterday, the 12th of May 2025. So the aim of the government really is to reduce net migration, is to reduce the numbers of people coming and staying in the United Kingdom. And the white paper comments on different routes on immigration. It comments on students, points-based systems such as students, um, skilled workers, and it also comments on family, and then it also comments on the asylum or protection routes. So this document is around 76 pages long, and I will be going through the main pages or paragraphs or portions that I've identified to be the important sections within this particular document. So bear with me as I will be going through the document and explaining to you what I understand or think about the proposed law. If you have got any questions, please you can put them in the chat and I'll be able to go through the questions through the chat. So, in paragraph 27 of the white paper, the government states that as part of these processes that they want to do, it includes a series of specific and stronger visa controls, such as increasing the threshold for skilled worker visas to graduate level. So, we reduce lower skilled migration, only allowing a narrow list of critical shortage occupations onto the temporary shortage list. So the immigration shortage list is going to be get rid of, and they're going to introduce a new list which is called the temporary shortage list. Um, Closing the social care visa route to overseas recruitment. I will speak on that more as we proceed. Restricting dependence for lower skilled workers on the temporary shortage list and increasing salary threshold for all visa holders seeking to remain in the UK or to bring dependents in the UK. Increasing English language requirements for visa holders and dependents. So in paragraph 34, they continue to say economic migration shot upward training of the domestic workforce has fallen and lower skilled migration soared while the proportion of UK residents in work fell. The surge in lower skilled migration, particularly in the care sector, also saw an increase in the abuse and exploitation of workers paid at wages that are undercut, um, and in many cases, there was breaking of the law. So these are some of the things that the government, according to what they are saying, they are seeking to address. Issues to deal with exploitation, lower wages, um, and what they think that is underqualification or reduced qualification in terms of what they think that a skilled worker from abroad should be able to bring to the UK. In paragraph 53, the document states that in 2023, there were 105,000 visas issued to care workers and senior care workers, representing 73% of youth and care worker visas issued to main applicants. The growth in visa demand for main applicants was also accompanied by a large increase in the number of work related visas that were granted. As you would know, this was curtailed or was reduced last year when the Home Office also made the decision that those people that have come to the UK after April 2024 will not be able to bring their dependents. That also meant that there was a significant reduction of people that were coming to the United Kingdom because most people they wanted their families to join them. So, in addition to that, the Home Office or the government is now proposing to reduce further the numbers of people that will come under all the skilled worker visas and particularly the care visa, which is going to come to an end because of the new proposals that have been made or said by the government. So the people that were coming on the skilled worker visa, as we will know, um, they were not necessarily expected to have a certain level of education. They were not expected to have a certain level of experience. You could just come with basic experience, basic education, or even with no education or no experience at all. Um, but the only thing that we expected to do was to write the English test. And if you will pass the English test, then the employer, subject to their own due diligence in their recruitment process and their HR, would have recruited you um, to show that you will be able to execute your duties and that they had a genuine vacancy that they were fulfilling. So one of the things that is now that is being proposed by the government now is that um, the requirements in terms of education or in terms of skills of any skilled worker that is going to come to the UK is going to be increased because it used to be at RFQ level 6 and they reduced it to RFQ level 3, which is an equivalent of A level. Now they are taking it back to the equivalent of a degree, and also the salary thresholds are going to be increased as well. So they have introduced what is called the immigration salary list, which gives people discounts from salary thresholds that will be abolished where there is demand for that particular profession or people, particular group of people that might be required. The immigration salary list um, will be abolished. So, like I've said, they've said that they've introduced what is called the new temporary shortage list, which is replacing the immigration salary list. And they're saying it's going to be stricter and they're going to streamline the professions that will be able to fit into the temporary shortage list. And they're going to increase the level of education or qualification that is required to RFQ level 6, which is equivalent to a degree, which obviously, as I've said, that will mean that the K work visa is going to come to an end for new entrants. Those who are already on the K visa already will not be impacted or affected, but I will comment on that as we go on. So, under the social care visa, they are going to establish what are called the fair pay agreements, which will empower the worker, employer, and other sectors to negotiate improvements in terms of employment. As we speak at the moment, the employer seems to have an upper hand when it comes to the social care visa, particularly with carers. The carers are at the mercy of the employer because they are A, tied to one employer, and B, the employer is the one who is almost determining, although they are guided by the rates that have been set by the Home Office, but they determine most of the things that the employee is to do. But under the fair pay agreement, that is going to change. So that is going to hopefully bring favorable conditions for the carers. The care visa is going to come to an end, and they have put what is called in transitional period. And in the transitional period, the people that are already in the care sector will continue to work in the care sector or can continue to work in the care sector, can change jobs within the care sector, can meet the same the requirements that they were meeting. And the transitional arrangements are there until 2028. So you can apply for an extension, you can do an in-country switching, and your rights will be protected. And they are saying that this will be kept under review, as they know that there's been a lot of abuse under this system of the care visa. At the moment, we've got the regional hubs which have been established to help the carers as well. So the transitional period is for people to continue in the care visa, but the transitional period, as I will comment later, seems not to have been said about um, the visa route or the visa pathway of an individual to go through settlement and citizenship. Because at the moment, as we speak, if someone is on the skilled worker visa, they are entitled to apply for settlement after 5 years. But as I will explain later, it means the Home Office is proposing that it will be increased from 5 years to 10 years. The government is also proposing that they will also draw a pool of people from people that are claiming asylum or have claimed asylum, and they will be put on a proposed sponsor worker route, which will be which will mean that most likely, if I am correct in my understanding, that people that might be seeking asylum or on the asylum route might be able to get employment through that route. But again, the government is very keen to stop people from coming to the United Kingdom and claim asylum. So in paragraph 83, they say, drawing from the experience of the Displaced Talent Program, we will explore reforms to allow a limited pool of UNHCR recognized refugees and displaced people living overseas to apply for employment through our existing sponsored worker routes where they have the skills to do so. In paragraph 84 of the document, the government says that the Immigration Skills Charge (ISC) has not been increased, or it's not been increased or subject to a comprehensive policy review since its introduction in 2017. So the government is now making a proposition that the ISC, which is paid by the employer when they're employing someone on a skilled worker visa, the employer pays the course fee, the certificate of sponsorship fee, and the immigration skills charge fee. The Home Office or the government is proposing that they will do a 32% increase on the ISC. Obviously, this is a way to try to discourage employers from recruiting people from abroad, and that they have to focus on people that are in the United Kingdom first. So it's going to be introduced or at 32% increment once the deliberations by the government have taken place. So let me just go through paragraph 89 of the document, which says, as part of our mission to promote growth, we will go further into ensuring that the very highly skilled have opportunities to come to the UK and access our targeted routes for the brightest and best global talent by increasing the number of people arriving on very high talented routes alongside faster routes for bringing people to the UK who have the right skills and experience to surcharge UK growth in strategic industries. As part of that, increasing places to our scheme for research interns, including those working in the field of artificial intelligence, to allow businesses access to additional promising young talent. Make it simpler and easier for top scientific and design talent to use our global talent visa. Review our innovator founder visa to ensure that it supports entrepreneurial talent. Double the number of workers that an overseas business can send to the UK with an aim of establishing a presence in the UK. So those are under the global talent, the highly skilled, the people. Those are the proposals that are being made by the government. So if you are someone who is highly skilled, you are an IT expert, you are a scientist, a researcher, the government is introducing these changes as well. Um, these have always been areas that the government has always respected when you a high-end person in the society. There's been routes that have been available for such individuals. In terms of students and in terms of universities, um, as would have noticed that from around 2021 going forward, there's been a surge of people that are coming to the United Kingdom to study. And most of these students are not going to what are regarded as the top tier universities. They are going to middle or lower tier universities that are A, cheap, or a B, that do not necessarily have an enforcement policy that is strong when it comes to their students. So, as such, students have been taking advantage of the system, uh, paying lower fees, and sometimes when they come to the United Kingdom, they do not finish their courses. Some of us will remember that um, again last year the Home Office had to implement a policy that you cannot recruit on a permanent basis someone who has not finished studying their course that they came to study. So it is along those lines that the Home Office has also introduced penalties for universities that fail to keep the basic compliance assessment requirements, and they've increased the threshold of requirements on the universities so that the universities will be compliant. So they've introduced more like a traffic light system of putting universities on red, amber, green, where they've been preaching. If you've preached with the amber, red, and you might have your sponsor license as an academic or educational entity revoked by the Home Office. Another thing that the Home Office is seeking to curtail or to deal with on the issue of students is A, claiming asylum, B, bringing of dependents, and C, postgraduate visa, which they're going to reduce to 18 months. I beg your pardon. So in paragraph 119, the Home Office of the government says to ensure the misuse of student visas, I beg your pardon, to prevent the misuse of student visas, we will strengthen the requirements that all sponsoring institutions must meet in order to recruit international students. The following measures will be implemented to this end. We will raise the minimum pass requirement of each basic compliance assessment BCA metric by 5%. Simultaneously implement a new red, amber, green banding system to rate the BCA performance of each sponsor. Introduce new interventions for sponsors who are close to failing their metrics. Require all sponsors wishing to use recruitment agents for overseas students to sign up to an agent quality framework. Together, these measures will ensure that sponsors are encouraged to recruit their students responsibly, only offering places to genuine students who meet the requirements of the audit, and ensuring that they are failing, where they are failing to do so, they are stronger power for the Home Office to intervene and ensure greater compliance for the future. So that is the bit to do with students. The government is also going to deal away or to consider dealing away or to discuss about short-term visas where someone comes to say to do an English course for about 6 months or 11 up to 11 months. The government is not keen for people to continue coming under that road. And for graduates, as I've said, the government is going to reduce the graduate visa to 18 months. Under family, the government is complaining that the family roots have been abused and misused by people, and people rely on the European Convention of Human Rights and rely on exceptional to proportionate circumstances. And the government is saying they are going to do an overhaul of the system and the family. They are going to implement new policies, new procedures, deal with applications that are currently falling under the ECHR Article 8 and the articles and so forth. So those are the reforms that they are going to bring in. So the government is stating that we would therefore reform the framework for family migration. We would tackle the over-complex family and private life immigration arrangements, where too many cases are treated as exceptional rather than having a clear framework. Before the end of this year, 2025, that is, we will set out a new family policy that will cover all UK residents, including those who are British, settled on work routes, or refugee seeking to bring families to the UK. You have clear relationship requirements designed to ensure only those in genuine subsisting relationships qualify. Reduce forced marriage and include protections to victims of domestic violence. Ensure those coming to the UK have appropriate level of English language skills to be able to effectively integrate into local communities. Ensure the family unit has a sufficient money financial to support any migrants without relying on the taxpayer through reviewing and extending the financial requirements to other dependent roles. Ensure that those who serve or have served as members of HM armed forces, bravely protecting our country and their dependents, have their rights to reside in the UK and become British citizens protected in line with the government commitment to them in the armed forces government. While this work is undertaken, it is important to take steps to make the system fairer. We have already commissioned the MAC, the MAC, to look at the financial requirements on family routes, and our further asylum reforms will cover family too. We also explore tightening the suitability requirements on the family routes to ensure people are of good character. We will introduce changes to the English requirement. So these are the changes that are going to be made under the family route. Effectively, it's an overhaul of the family route that is going to happen. So we will see a lot of changes that will happen to the immigration rules, to the appendixes, to the policies, to the guidances, and they've particularly mentioned also the good character requirement. The good character requirement is always a requirement in all applications where you have to declare whether you've got criminal convictions, and if you've got any county court judgments, anything that if you are a sympathizer or a supporter of terrorism, one way or the other. So that is going also to be dealt with. The issue of exceptional circumstances is also going to be reviewed by the government. Okay. If you have got any questions, please do not hesitate to put in the chat. I'll be able to reply to the questions as much as I can. So the government, on the issue of exploitation, as they have said that there's been exploitation, particularly in the care sector, and sometimes and other areas as well. The government is saying that we will explore introducing further reforms to our sponsorship system, putting more responsibility and accountability on effective and responsible sponsors. This will include exploring making it easier for workers to move between licensed sponsors for the duration of their visa, giving them more control over who they work for and reducing the risk of exploitation. I think this is a very welcome proposal by the government because at the moment, the employers seem to have or do have more power or more control, but the government is saying that they will also make it easier for employees to move between the employers as much as possible. So, how it will be panned out, we will be able to see it in the future. Instances of modern slavery and labor exploitation continue to be seen amongst those who held visas as domestic workers who reconsider the purpose of this route acting to stop employers exploiting their staff. Uh, there's been a high profile case in which a United Nations judge was exploiting someone as a domestic worker. I'm sure some of those things that the Home Office is seeking to address. We are also introducing a new offense of criminal exploitation of children in the crime and policing bill to go after the gangs who are luring young people into violence and crime. We will increase convictions of exploiters, deter gangs from enlisting children, and improve identification of victims. They go on to say, we recognize the challenge migrant victims of domestic abuse can face and will strengthen the protection in place to support them to take action against their abusers without fear of repercussion on their immigration status. Again, apart from the things that happen between employer and employee, we are also privy to circumstances whereby domestic violence is being perpetrated by spouses or partners on each other or on children. So the government is proposing that they will deal with with that situation in a better way. As we know at the moment, even for people that are on the skilled worker visa as a main applicant or as a dependent, particularly dependent, and if you're a victim of domestic violence, you can be entitled to go on the 3 months protection or 3 months domestic violence visa in court so that you'll be able to sort out yourself, either leaving the relationship, getting your own visa, sorting out your immigration status, and so forth. So another interesting point in the white paper is that the government is saying that um, they are going to extend the rules that apply to banks. You know, at the moment, you cannot open a bank account if you're illegally in the country, or there's always checks. You have to produce your share code and so forth for those checks to be done. But the government is saying that we will extend the rules that apply to major banks to prevent illegal working to other financial institutions. So all other financial institutions, I would assume all those regulated by the FCA or one way or the other will now be required to check on you before they can maybe deal with you. So it's going to be extended. We will review these controls and ensure that they are appropriate and reflect recent advances in technology across all sectors. We know that certain banks as well have been easier for people to open online. These new disruptor banks that are available online. We will work with HMRC and HM Treasury on applying immigration enforcement measures to those applying for visas or here on visas who have not paid taxes and that they owe in the United Kingdom. So, if you that also goes to the good character requirement. If you are not meeting the good character requirement or if you are not paying your taxes, the government is going to crack on that. And if you are still owing your taxes, then the government is also going to crack on that. They are also going to strengthen, as they say, their enforcement or dealing with foreign national offenders. Uh, they said that on foreign national offenders, the government is saying later this year we will set out more detailed reforms and stronger measures to ensure our laws are upheld, including streamlining and speeding up removal processes. This will include establishing new processes so that the Home Office can more easily take enforcement and removal action, revoke visas in such a wider range of crimes where non-custodial sentences have been given, not just cases where you are sent to prison. As we speak at the moment, if you've got a non-custodial sentence, then you are not subject to removal. And also, if you've got, I believe, if you have got, it also goes to affect your, your good character, if you are not rehabilitated and so forth. If you have got a conviction, for example, drink driving or RTA cases, they might affect on your settlement, but not necessarily on your deportation or removal. But now the Home Office is considering, and this is a very drastic action that the Home Office is going to take. They will consider to remove you from the United Kingdom even for non-custodial sentences that have been given. So we'll see how this is going to be worked out. Are you going to be removed from the UK simply because you've gone through a road traffic light, or you have got a non-custodial sentence that you have been given? But my word to you is just err on the side of caution so that you do not have any convictions. It is right that we take action against foreign national offenders in the United Kingdom before they get the opportunity to put down their roots in the UK, and that we do what is necessary to protect the British public against criminals before their offending escalates. The next point, which is also important that the Home Office is going to change, is on integration and cohesion. The Home Office, they've been talking about this for a long time, implementing different strategies over a period of time, and this is in line with that. They want people to integrate in the United Kingdom, to be part of the community, to take part in whatever happens in your neighborhood, in your church, your mosque, your temple, uh, playing football, support local teams, go to the local food bank and do activities. They want you to integrate, or they want people to integrate. So this is something that they have um, proposed in this white paper, and they say in paragraph 238, successful integration helps support people to realize their full potential and benefit local communities. Being well integrated means individuals can access services, overcome educational and health inequalities, find jobs, and contribute to social cohesion and community empowerment. To achieve integration, paragraph 243, and make most of the opportunities on offer, individuals need to be able to mix and become active participants in the communities in which they live. Crucially, that they should be able to speak English. And in my practice, I've met some people that even after 10, 15 years in the UK, they cannot speak English. They still speak their mother language, and they have to come and see you and talk to you with an interpreter. So those are some of the things that the Home Office is looking to break down on. They want people to integrate and to take part whatever happens in the community. And this was why things like the English test was previously introduced and life in the UK to help people integrate. But the Home Office is taking the steps further. So, under the English language, the Home Office states that, or the government states there, that the ability for individuals to communicate is essential to perform civic duties and for all social connections, including crucially with the communities in which they live and with state and other agencies such as local authorities and non-government services. Without adequate language skills, there is a risk of isolation as well as poor integration. So the Home Office wants people to do English, and in line with that, um, the Home Office observes that in paragraph 251, there are currently no requirements on English proficiency for adult dependents arriving in the UK on many of our work and student routes. And this is going to change. There will be implementation of this. So the change is that we will introduce new English language requirements across a broader range of immigration routes for both main applicants and their dependents, ensure better knowledge of English, including an assessment of improvements over time. So the dependents are going to be, the adult dependents are going to be required to undertake an English test. One of the days where they require the um, dependents would come without doing the English test. We will increase language requirements for skilled workers and workers where the language requirement already applies from B1 to B2 independent user levels in accordance with the Common European Framework for Reference for Languages, CEFR. So they are going to put it up at the moment, even for those who are coming on the care visa, they were doing the B1 and now it's going to be the B2. It is important that we ensure better integration and consistency in our requirements of family members across the immigration systems. So we will introduce a new English language requirement for all adult dependents of workers and students at level A1 basic user to align to spousal and partner roles, and we will work towards increasing this requirement over time. We want individuals to improve their English language skills over time as they continue to stay in the UK. We will introduce requirements to demonstrate progression to level two for any visa extension. So if you apply for a visa, you do an extension, they will increase it to the next level until you get to the B2 level, um, which is the one required for settlement. We increase our existing requirements for settlement across the majority of immigration routes from B1 to B2 independent user. So those are the English requirements. So dependents are also now going to be required to be able to speak English, to utilize English, to write English exams. When it comes to settlement, and this is where I've been receiving a lot of questions from people that are in the UK who came here uh, recently, particularly those who are on the care visa. Um, there is what is now called the end settlement. So for settlement in paragraph 259, page 68, settlement in the United Kingdom is a prerequisite for becoming a British citizen and it brings lifelong benefits. Settlement is also an important step in integrating and contributing to local authorities and the wider community. It has been a long-standing principle that settlement in the United Kingdom is a privilege and not a right. Under the current system, settlement is primarily qualified for on the basis of length of time spent in the United Kingdom, alongside the knowledge of the life in the life test and the English test, which test like British customs, history, traditions, and so forth. But the proposal that the government is put on the table is that we will therefore reform the current rules around settlement through an expansion of the principle behind the point-based system that individuals should earn the right of privileged immigration status in the United Kingdom through long-standing contribution they bring to our country. So it's more like you're going to earn your settlement. It's we will see how they're going to implement this. To be honest, because it's no longer just an issue of you spending time in the UK and you get your settlement and you do your English test or you do your life in the UK test. They're saying you have to earn it, and how to earn it. We will see the flesh to the skeleton with whatever legislation that is going to come into play. This expansion of the points-based system will increase the standard qualifying period for settlement to 10 years. So settlement across the board is going to be 10 years. And for the carers, as I've said, there has been previously, as I've said, the Home Office has spoken of transitional arrangements, of them continuing to work in the industry, swapping or switching employers, and that these arrangements are going to be in place until 2028. As to the settlement, whether it's for the skilled workers, um, it's it is just mentioned that it's going to be increased from 5 years to 10 years. The government at this stage have not mentioned whether they are going to put any transitional arrangements. The government um, do have when they're doing legislation the transitional arrangements. But it's not always that they do transitional arrangements which protect people that are already in the UK, but which are already on a particular visa route to say that you're already there, you're not affected. In other words, they are not retrospectively affecting people who have got a legitimate expectation of a certain result or action. That has not been said here. We will expect them to say maybe they will respect the people that are already in the UK and they will continue on their current routes on 5 years because that was their legitimate expectation. But it's also common that they can still implement it. In 2012, they went also get transitional arrangements and some didn't try transitional arrangements. Last year, they made laws that did the transitional arrangements which protected carers that are already in the UK to be able to bring their dependents from abroad and so forth. As to how this is going to pan out, it's something a wait and see game and see what the government will say there. I believe they will do a transitional arrangement. They might not do the transitional arrangement. If they do not do that, then they're likely to be challenged in court. There's an abuse of power, really, for not recognizing that people have been here on a particular road. So, as we state, paragraph 264, the expansion of the points-based system will increase the standard qualifying period for settlement to 10 years. 265, we will continue to offer a short pathway for settlement for non-UK dependents of British citizens to 5 years. So if your sponsor is a British citizen on a family route, it's not going to go up to 5 years. And I would want to believe that this might also be able to cover dependents of people that are on indefinite leave to remain, provided they've remained compliant with their requirements. We will retain existing safeguards to protect the vulnerable, including settlement rights for victims of domestic violence and abuse. Through the expansion of the points-based system, individuals will also have the opportunity to reduce the qualifying period uh, on points-based system in the United Kingdom because of their contributions to the UK economy and society. We will consult on these changes later this year. So, the point here is that they are doing what is called we will retain the existing safeguards to protect the vulnerable. You know, that end settlement, what you do in the community, and also a new settlement and so forth, and how it's going to be done, we will be able to see how it will pan out. The last point on end settlement. Whilst we develop and implement the new end settlement model, we will make further changes to settlement rules in the near term. These include the creation of a new bereaved parent route, allowing those in the UK on the route of a parent for British or settled child who have yet tragically lost their children to settle immediately. ensuring children who have been in the UK for some time, 10, 18, and discover that they don't have their status are fully supported and able to regularize their status and settlement. This will also include a clear pathway for those children in care and caregivers. So I think these two last points are very good points where they will allow grieving parents to get a settlement immediately. And for children that are in the UK who don't have settlement or who don't have leave to remain, to be able to be supported to get their visa and get their status as settled citizens in the United Kingdom. On citizenship, they've introduced what is called earned citizenship. It has been a long-standing principle that citizenship in the United Kingdom, like settlement, is a privilege and not a right. We are creating a system that benefits people who respect the rules and make their contribution to the UK and take action against those who do not. We will introduce reforms to citizenship to align to end settlement reforms, building on the expansion of the points-based system to settlement and citizenship. Similar to end settlement, we will increase the standard qualifying period. So at the moment, if you are on settlement, you do 12 months on settlement, and then you can potentially qualify to become a British citizen. Most likely, what they are going to say, you have to be on settlement for a number of years. Maybe they will say you have to do 5 years on settlement, again, or 10 years on settlement before you become a British citizen. So they are going to increase that period as well. So paragraph 271 says, similar to end settlement, we will increase the standard qualifying period and expand the points-based system to allow those with greater contributions to qualify sooner. But those ones who are in it with people or people that have done qualification and contributed something to the community will also be able to get their citizenship quicker. We will also conduct a refresh of the life in the UK test and how it operates. Finally, we'll consider measures to reduce the financial barriers to young adults who have lived here through their childhood to accessing British nationality, and that is a positive point. So, in summary, what I've been saying, don't see any questions. If you've got any questions, you can put them in the chat. In summary, there have been reforms under the points-based systems for students and for workers, and under the family route, the protection route, and some general issues on immigration. They've increased the level of skills required to RF Q6. They are also going to increase the salary threshold. They are going to close the care visa, and there are transitional arrangements that will be there until 2028. Settlement will be after 10 years. We are yet to see how, if there's going to be any transition arrangements or how it's going to be worked out. They are going to penalize any universities that do not comply with the new laws, as well as new employers or employers that do not comply with the sponsor duties that they have. And dependents are going to be required to write the English test. The adult dependents are going to be required to write the English test. So it's all about tightening the law, reducing net migration, giving opportunities to British people, and asking people to integrate into the community. So I think you one of the days whereby you just go to work and come and sleep in your house, going to work and come and sleep in your house, you might need to produce evidence that you are going to the pub next door and having a drink with other people with Joe or Sue or Sophie, whatever it is. And you're doing activities within the community, integrating yourself, particularly with the English requirement, which they're going to increase the level requirements. And each time you extend your visa, though you'll be writing a new English test as well. And for the graduates, it's now reduced from 20, I think it was 24 months or 30 months, but it's now 18 months. For the short visa of the English one, they're going to scrap it. So in a nutshell, I think I've tried to cover everything that is in the document. It's a long document, 78 or so pages. That's the document. It's called the Restoring Control Over the Immigration um, System. Thank you so much for tuning in and listening to the presentation. I do not have any questions that are there. And if you've got any questions, you know where to find us. My name is Andrew. I'm from Tan Law Solicitors. You can contact me on the details that are on the screen, and you can also uh, like our Facebook page, or you can subscribe to our YouTube channel. We have got more than 150 um, videos on the YouTube channel and discussing a lot of things that we normally deal with in our office. In our office, we do things like immigration, employment, family, business advice, wills, and probate. Thank you so much. I will meet you again next week and have a good evening.